And are you pleading guilty because you actually did what they've charged? All right, are you Showdown Mitchell? And will your client waive the formal reading of the indictment?
No back muscles. 2, 3, 4, last one.
Ms. Mitchell, in cause number 24, DCCR 2270, you're charged with the state jail felony offense of theft of property from August 11th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Comerford? Do you fully understand them? And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 3-year deferred probation. Looks like y'all agreed to a $500 fine, but there's also almost $4,000 of restitution. Okay, I'm
We're okay with
inclined to reduce that. I'd much rather the restitution. How old are you? Okay. So the restitution would be $3,999.68. Is that your understanding? And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal? Also, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. It's admitted. Is there any evidence that Ms. Mitchell is not competent?
There is not.
And is there any reason not to go forward today since y'all have the restitution amount? All right, so Ms. Mitchell, I'm going to find that you entered your plea of guilty freely and voluntarily. Fine. I'm sorry, did you just do something? I'm seeing movement. I thought so. That's okay. I thought she needed something on your case. All right. No, you're fine. I'm going to find sufficient evidence. I find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to waive the pre-sentence report. I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for a period of 3 years. I'm going to order a $250 fine, and I'm going to order that you pay restitution in the amount of $3,999.68 and follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have a felony conviction on your record. And if you successfully complete the probation, at the end, the case is actually dismissed. You will never have a felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court. You could be found guilty, so you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? So $4,000 is a lot of money for anyone, especially someone your age. And so it's very important to me that you start making payments on that immediately, even if it's $20 a month. Some people think, well, I'm going to wait and get my tax refund, or my family's going to help me out in 6 months, and all of a sudden you're at the end of 3 years. And if you haven't paid that restitution, and I find that you could have paid it, you could do everything else right on your probation, and I could still send you to prison. So I want you to make some payment every single month. It'll add up over that time. All right? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Also, do not ever show up in court with your midriff showing again. I don't need to see your belly button in court. Okay? You're in felony court. Dress appropriately. That's important. It's time to kind of grow up. You're on a felony probation. You need to do things in an adult way. And dressing like that is not an adult way to show up to court. Okay? You need to have a seat here in the courtroom. Probation's going to call you to her desk. She's right over there. Watch for her to call your name, and then she'll go over your paperwork with you. Okay? Good luck to you, ma'am. Thank you, Mr. Comerford. Good morning.
7.
Judge, we are winding down on this. We got an offer since our last court date. It has $80,000 in restitution. So what we're asking the court is give us a little bit more time to vet that, the proof of services for that, and see if that's something that we could come up with up front to help resolve the case. I did find, I looked and couldn't find them. I did find the proof of services for that $80,000, so we need to go through it. I have not seen it. That was added in discovery at a later date than when he came to the office the first time.
Okay. Any issues?
No, if you recall, when we first came in here, we were still waiting for.
Right.
Because the cleanup was still.
Right, and so y'all got everything's here, you've got it all? Okay,
It's been sent, we should be.
perfect.
Done next day.
So we'll do one more reset, and Mr. Rucker, make sure you go in, visit with Mr. Galmore, go over all of that discovery so that we can figure out an announcement at your next court date, which direction your case is going to take, okay? All right, thank you.
And just like that, the judge shifts from compassion to business. Watch now. This is where every word starts to matter.
All right, his bond will be forfeited for non-appearance and reset at $100,000. He did call, say he was having issues. If he gets here late, then I'll obviously recall that bond forfeiture.
And Judge, like I
You've
said,
got Karis and, oh, go ahead, I'm sorry.
he did call this morning. When I tried to call him back to his house number, he was already gone, so I'm assuming he is trying.
Maybe on his way. Okay, thank you. And then you've got Karis and Twine, Mr. Lewis.
Yes, my Judge.
2, 3, 4.
Are we? Okay. You're Karis Antoine, and this is cause number 24, DCCR 1878. It looked like I did sign an order back in May for CPS
You
records.
did, Judge. We contacted them this past week asking for an update. They hadn't gotten back with us yet. I even had Mr. Hoppower call because he's used to dealing with them.
Right.
And he did that for me at the end of the week, and they hadn't replied yet.
All right, we'll reset that just another 30 days. If you'll make a sticky note for us, we'll try to contact them as well and see if we can, sometimes that helps to get things moved
So
along.
reiterate what said, I spoke to him by email.
Okay.
To the front.
But we
What we're going
started
to do now is.
And she didn't give any update on when we could expect them?
It was Friday.
Arms are on.
Okay.
Arms actually sit a little bit further back in the
She's
chair.
usually pretty responsive. All right, so Mr. Antoine, stay in touch with Mr. Lewis. He'll let you know once he gets that information so you can go in and go over it with him. And then we'll try to get an announcement, hopefully if we get that before the next court date.
Thank you.
Thank you.
And off the record,
Good morning, Mr. Rojas. Good morning, sir. Are you Carnell Beard?
Underneath you, go left, again, heels
And
out.
will your client waive the formal reading of the indictment?
3, 1, 2, that's 1, 3, excellent work, have a little rest, slouch over, get back into that upright posture, core tight, let's go for another 5, you can do it, let's go, follow along with me, heels out in front, excellent work, toes underneath you, and 1,
Are we
2,
going on count one? Oh, no?
No, ma'am.
Okay. Okay, let me,
4, that's 1, 5, excellent work, shaking out those legs, taking a deep breath in, and out. Okay, we're now going to work your hips, so sitting in the middle of the chair, up nice and tall, hands on your armrests.
all right, and he'll waive the formal reading of the indictment. Mr. Beard, you're charged with the third-degree felony offense of collision involving serious bodily injury from September 28th of 2024. Your indictment also alleges that you were previously convicted of attempted murder, second-degree felony, August 30th of 1999. And after that was final, you were convicted of possession of a controlled substance, a first-degree felony.
1, 2, 3.
Well,
Judge,
do we just need to go on one, or
Let's
is
just
that?
go on one because I'm looking at the dates and they do overlap, so it would not make them.
It wouldn't, so it makes it a second-degree felony. So what that means, sir, is that the punishment range in your case would be enhanced to that of a second-degree felony, which is between 2 to 20. Do you understand?
4,
And how do you plead to that charge? And is that prior offense true?
outwards direction.
Okay. Did you enter your plea of guilty and true freely and voluntarily? Attorney, that you will be waiving or giving up any right to appeal. And it looks like the agreement that you've reached is for a 10-year deferred adjudicated probation. There would be a $1,000 fine, and there would be restitution ordered as determined between now and when we come back for pre-sentence, through a pre-sentence report. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Beard is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case. We'll also get that restitution amount determined. And then we'll come back later for sentencing. When you're on your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right there. All right, we'll see you back at sentencing. Good morning, sir. Are you Zachary Turner? And this is 24 DCCR 2197. And Mr. Turner, you're charged by indictment in this case with the first-degree felony offense of fraudulent use or possession of identifying information from April 22nd of 2024. Your indictment alleges that you were previously convicted of unlawful possession of a firearm by a felon, a third-degree felony, September 29th of 2014, which means that this, for punishment purposes, would be enhanced, but
1599 is the way we indicted, Judge.
right.
Given the rejection of the state's offer today, I believe we can make him a habitual, and I will be filing a habitual offender notice in this case.
So, and you've gone over that with Mr. Rojas, correct? And so I want to make sure you understand that if the state files that notice of enhancement with another prior offense, which I would assume you have since the one I see is an unlawful possession of a firearm by a felon, that means that if you go to trial and you're found guilty, the minimum punishment would be 25 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 15-year term.
This is one of the most critical moments on today's docket. The judge is making absolutely certain that the defendant understands the consequences of rejecting the state's offer. What makes the situation so significant is that the current offer carries a known outcome, while trial introduces enormous uncertainty. If the prosecution files additional enhancement notices and secures a conviction, the sentencing range could increase dramatically. That's why judges carefully explain these consequences on the record, to ensure nobody can later claim they didn't understand what was at stake. Cases like this often come down to a difficult calculation. Accept a lengthy sentence today, or take a chance on trial and risk something far worse. What would you do in this situation? Would you take the deal, or would you fight the case in court knowing the potential punishment could be substantially higher?
Term in the institutional division of the Texas Department of Corrections, and I would assume that would be going on count 1 only.
7.
And so you have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. Mr. Turner, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? So, Mr. Rojas, you're released. Mr. Turner, if you'll just have a seat here in the courtroom, I will appoint someone. The clerks will call you up in just a minute with that information on who your lawyer is going to be. I also want to make sure you understand that after today, I will not accept this plea agreement. Once your case gets put on the trial docket, it either goes to...
This is the heart of Courtroom Deals guilt paperwork and consequences wrapped in calm voices. But behind every yes, sir, is a life about to change.
Trial, or if you change your mind, you can plea open to the court or to some different plea agreement unless there is new information that your attorney or the district attorney's office receives. Do you understand? Okay. If you'll just have a seat, she'll call you up in just a minute.
2. 3.
Good morning, you're Nakia Brandon.
4.
So, Mr. Brandon, you're ordered to have a drug patch, and it looks like you've had some issues with that. Have a seat in the jury box. We're going to get you tested this morning.
9, the last one. 10, that's solid. Bring those feet in.
TJ Landry, looks like that's set for a plea.
He's been having a lot of financial difficulties.
Hold on.
Down nice and slow. 1.
All right, this is 24 DCCR 0165, your TJ Landry.
5.
And this,
7. Three more to go. 8, 9, last one, 10. Excellent work. Slowly coming down.
I've tried,
Leaning back,
I've been patient with Mr. Landry to, you know, fulfill his financial obligations, and he just.
Are you working?
Away from you, bring them in towards you. And let's go for 1. Bring the toes up. Down, pushing away from you, bring those toes up. Excellent work again, pushing those toes away from you, bring them up. Let's go 1, toes away, toes up. 2, toes away, toes up. 3, toes away, toes up. Let's go for 2 more. Toes away, toes up. And last one, toes away, toes up. Excellent. So same thing on the other side. We did about 8
The thing
reps
is, if
on that other
he
leg.
qualifies,
8
it's
reps.
going to be you,
On this side,
because you
so
were
toes
initially
away from
appointed,
you, coming up, that's 1.
which
Toes
isn't
away from
super
you,
fair, I
up, let's go
understand.
6 more. Toes away from you,
Y'all have
Toes
something
up.
worked out?
toes away from you, toes up, let's go 4 more, toes away, toes up.
If there's an
Toes away,
agreement for probation, I think the
toes up, let's
state
go 2 more,
is
let's
asking
go
for
1.
straight, we're asking for deferred.
Bring it away, bring you up, excellent work. Again, toes away, toes up towards you, excellent work. Taking a deep
I'll
breath
I'll
in.
get the paperwork.
Yeah, I don't, well, it's going to be either way. I don't, on this one, just because of,
3,
where are you working?
4, 5, excellent work. Let's go the other way. 1, 2,
When did you just get back to work?
Thursday last week.
5, onto the other leg now, into circles. 1, 2,
When is your next payday?
4, 5,
Thursday.
and coming the other way.
You get
1,
paid every Thursday.
2, 3, 4, and 5. Great work. Taking a deep breath in
What I'm inclined to do is,
and out.
even though it's been going on, is reset at one time to give him some time to take care of some of the obligation to you, Ms. Holmes, and then we'll take care of it at the next court date.
Yes, ma'am.
I should be okay because I took
You need to
care
take care of Ms. Holmes. She's been working on your case very hard, and so it sounds like she's got a good offer for you. And now that you're working and you're working full-time, I would expect you to hire someone. You've done that. You need to try to take care of that obligation. I'm going to reset it 30 days. I want you to get with her, take care of as much as you can with her, and then we'll take care of it at the next court date.
Yes, ma'am.
Okay, thank you.
All
All right, you're Edmund A. Latulis, and this is 24 DCCR 2057. Ms. Latulis is charged with abandoning or endangering a child, and what is the announcement?
Yes, Your Honor. So there's a co-defendant involved. Spoke with Mr. Hoffpower. He would like to meet with both me and the co-defendant's counsel.
Which I spoke to Mr. Burbank was here.
Okay.
We want to hold off on our announcement and make sure that we're doing that, but I think we have a resolution, but due to the nature of the facts of this case, which is a dead child, that's why I want to make sure we cross every I.
Well, and this one was, I have a notation that this one was going to go before the other one
Right.
anyway.
Right.
I didn't know that.
She needs to talk to her client about what our offer is in regards
Yeah,
to.
I was
Right.
looking off it this morning.
Oh, okay.
Right. Now we've spoken.
Okay, so let me do this. I'm gonna reset it, just a normal reset.
Okay.
That way you can go over any options with Ms. Latulis. Y'all get together. Mr. Burbank, Mr. Hoffbauer, y'all have 30 days to take care of all of that, and I want an announcement at that next court date.
Yes, ma'am.
Okay?
Okay.
All right, Ms. Latulis, stay in touch with Ms. Holmes, because you're gonna need to go visit with her before the next court date.
Okay.
6,
Good morning. Are you Zelly Valasila? And, Ms. Holmes, will your client waive the formal reading of the
She
indictment?
will, Your
last
Honor.
one.
And I'll
sit
email the
back,
attachment.
hold.
Okay.
You come up, you can wait for both legs, pushing those feet to the ground, coming all the way up, straightening the hips, straightening those knees. Excellent work. Shaking out those legs. Okay, now we're going to do another variation of the squat. This time, our legs are wider apart.
And Ms. Valasila, in cause number 24, DCCR 1364, you're charged with a second-degree felony offense of burglary of a habitation from May 8th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? And do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
6,
And it looks like the agreement that you've reached is for a cap of 7 years in prison. And what that means is that you're leaving your punishment up to me. And as long as I don't give you more than 7, you're waiving any right to appeal. I can give you 7, I can give you less. It'll all depend on the information that's brought to me when we have a sentencing hearing. You have
Today's courtroom session showcased a full spectrum of criminal justice decisions. We saw defendants receiving opportunities through deferred adjudication, others negotiating plea agreements, and some facing the harsh realities of prior criminal history and enhanced punishment ranges. The judge repeatedly emphasized accountability, responsibility, and the importance of complying with court orders, probation conditions, and restitution requirements. Perhaps the biggest lesson from today's proceedings is that courtroom decisions are rarely isolated events. A defendant's past conduct, current choices, and willingness to accept responsibility can all influence what happens next. For some individuals, probation represents a chance to rebuild their lives. For others, rejecting an offer or violating court conditions could lead to severe consequences in the future.
every right to have a jury come in and determine 2 things. The first would be to decide if you're guilty or not, and then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1, it's admitted. Is there any evidence that Ms. Valencia is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, make sure you get with Ms. Holmes and get that information to her. She'll present it to me on your behalf when we come back.
This moment is the turning point a felony erased. If she walks the straight line one stumble, prison the judge isn't just warning her, she's drawing the map.
You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Mr. Burbank, you've got Andrew Jackson.
2,
Your Honor, we have
3,
deal
Okay,
nice and slow,
with one caveat.
4,
okay.
5, way up, looking back, slowly down, excellent.
I know every...
6,
Take a deep breath. He is going to plead today, and it's for 12 years.
Uh-huh.
The girl wants to come and make a statement, if we can reset it for
9,
30
last
days or
one, reaching
whatever
back,
it
nice
is.
We'll
and
reset
slow.
for 1 week.
That's fine.
It's been reset enough. We'll do it on Tuesday on a jail docket. We've got jail here anyway.
He just needs to take care of some stuff.
He's got a week.
Yeah, that's what I'm saying.
Yeah, 1 week.
Because
It's not like this is a surprise.
No.
It's not. So you had 30 days to take care of this and time to get them here. So obviously, everybody knows this is a bit frustrating. Get the paperwork done.
we're doing it right.
And it will be 1 week to next Tuesday. Okay, all right.
He's going to take a plea now.
Okay, yeah, you get that paperwork done.
3, stand up nice and tall.
Good morning, you're Raymond Ryder, and this is 23-41597, and Mr. Ryder's case is set for trial to begin with jury selection on Monday the 8th, and what is the announcement?
Exact same thing, going for 8 repetitions.
All right, obviously this is quite old, so it's likely to be numbered at the top. Any changes with regard to negotiations or rejections that I need to go over? Hey, can y'all hold it down?
7, last one.
All right, so
Excellent.
Mr. Ryder, stay in touch with Mr. Kelly. He'll know tomorrow after my docket what the trial order is, but expect to be here on Monday the 8th for trial, okay? All right, thank you.
Thank you, Judge.
3,
All right, so you're John Garcia?
4,
Mark Garcia, sorry. And Mr. Garcia, it's very important that you're here on time.
same on the other side.
Leave earlier.
Let's go for 8.
So Mr. Garcia, let me get you pulled up here just a second.
3, toes are facing the front.
I will recall that bond forfeiture.
5, 6,
And Mr. Garcia, were you able to get anyone hired?
I'm getting close.
Okay, so let's get into some balance exercises now. So you're nice and tall next to your chair. 1 foot in front of the other, just like this. So 1 foot, toes of 1 foot touching the heels of the other foot, holding on to the chair.
Okay.
Until you found your balance.
All right, so what I'm going to do is reset your case about 30 days. It's important that you try to get him hired before that next court date. If it's not going to work out with Mr. Crenshaw, then you need to talk to at least 3 others and bring me those names. Okay? Step in front of the clerk. She'll give you a reset notice.
High-stakes negotiations aren't loud, they're quiet, tense, and expensive $80,000 on the line, and the judge's patience